And joining us in studio, Botsang Moelwa is a political analyst. Adil Nchabeleng, Transform RSA president, is on the line. Andile Mqitama, Black First, the Land First Movement national convener. And Oliver Dixon, a socio-political analyst. Tsepo Khadima, political analyst, and Cecilia Russell, ANN7 special projects editor, who joins us on our newsroom studio. Good evening to you, and thanks so much for joining us. Tsepo, let's just start with you in terms of the OKPAY group and the vindication today. Quite a significant turn of events.
Yes, very significant, but not surprising. I wish I could say that I am elated, because we at all times held the point that the application by the minister or former minister was not only legally absurd and untenable, but if anything, it was indicative of abuse of power and abuse of process. And of course, now it's common cause that the emperor is no longer on the throne. And the court effectively confirmed the reservations that we had, in fact, the dismissal that we had, that he had no merit, howsoever, to have approached the court. So that being the case, the question is, where do we go from here? What we have seen is that we saw the oligopolistic cartel of banks, and that's really what they are. They are a cartel, and cartels are unlawful in this country. So will the Competition Commission now take action against this cartel, because their conduct in concert of closing OKPAY's accounts in the first place is none other than being in contravention of the Competition Act. And for many occasions, I have raised the question as to what constrained the Competition Commission from having inquired and having taken action as was deemed necessary at the time. The other thing, of course, we know of the certificate that was one of the first indications of the absurdity of former minister's case, in terms of the so-called 72 suspicious transactions. That when the court dismissed that certificate, we have to take again into account what will Minister Malusi now do with this judgment.
We'll take it all in bite sizes. Sorry, Tsepo. We'll take it in bite sizes. Just to, for clarity, in that the court had unequivocally questioned the reasons why former Finance Minister Pravin Gordhan brought this motion in the first place, to ask for protection or declaratory order to say that he can't get involved. Your view in how this particular outcome materialized?
Well, Cindy, and good evening to our viewers. It is exactly 8 months today that we sat here and we said the Minister of Finance is wrong. We said the Minister of Finance is running away from his duties to perform the duties of managing and controlling the financial institutions, which includes insurance companies and banks. And he sought a relief from the judiciary. The judiciary has come back and said the Minister of Finance was wrong. What will happen from now moving forward is OKPAY is being vindicated. And they've put a position whereby it's very good for the country. We should look at it politically, that it was one company that the commercial banks of the country acted illegally and unprocedurally to close their accounts. It doesn't matter who owned the account. Now, if this matter had gone through with the court, it would have happened to Tsepo, it would have happened to me or to you next time. However, we are safe in this country today to say the court has not allowed the banks to conduct their business in a manner that is disregarding the policies of this country. And Tsepo is correct by bringing the fact that they tried to use 72 alleged transactions to stop OKPAY from conducting business in the country. And the Minister of Finance was trying to fold arms and say, I can't help. The Reserve Bank as well has been silent in this whole process. I sat on this platform 8 months back, and I said it is not possible and it is not correct that we have a Minister of Finance who, when there's crisis in the financial sector, he stands up and he says, court, please adjudicate me and remove me from attending to my responsibilities. Pravin Gordhan, as the Minister of Finance that time, was running away from the responsibilities of a Minister of Finance in the country. And I'm happy that this judgment has come up. It has not only vindicated us as analysts, it has not only vindicated OKPAY, it has vindicated financial processes in the country to say banks cannot conduct business as and when they wish in the country.
Yeah, well, we have Cecilia Russell, our special projects editor. Cecilia, thanks so much. You've gone through the entire judgment, word for word. And I mean, now, you know, OKPAY is vindicated. Our analysts are also ecstatic about it. But the fact that as taxpayers, we now have to incur the costs, while then Finance Minister Pravin Gordhan had 2 legal counsel or advice telling him that this wouldn't hold water, and yet he still went ahead.
Yes, the judgment is quite clear that, in fact, he acted, they don't say frivolous, but they say unnecessary. This is a completely unnecessary court case. He brought a court case asking the judiciary to get involved in a matter that should never have got involved in, and so they tell him off quite clearly that this was unnecessary and bad, and he disregarded you know these advice that he's got from legal people. The interesting thing about this whole case is there's a judgment and then there's the implications, and I think this really exposes the former finance minister's agenda as far as the FIC certificate was concerned. I mean, he applied for that FIC certificate before he planned to take this case. That was completely illegal, actually. I think that it opens up a whole range of different elements for OKPAY in the future, because he applied for this case before they applied for that FIC certificate. You only can apply for a legal matter, and then was almost obliged to put this FIC certificate out in the public domain. And as cynical people would say, and maybe it's not so far from the truth, that in fact he put out that FIC certificate to ensure that the OKPAY group of companies and the Gupta family would be seen in a light as if they are corrupt.
All right, hold on. Sorry, Cecilia. Now, I don't know if this judgment will change the perception, as our editor, special project editor, says that the court put aside all of this other mitigating circumstances where Pravin, or aggravating circumstances rather, of the 72 charges, Cebisi Jonas's affidavit, etc. Will this change the perception in your view, at least, if nothing else, shifted a bit?
It shifted it a bit. I don't think it changed it entirely, because further down into the judgment, which I read most, the greater half of, it speaks about OKPAY's third point of defense with regards to political motivations thereof. The court is not very declaratory on that. What the court is, however, very clear on, and I think the word here that was used is that this claim was unnecessary. If we break that down etymologically, that means that this was irresponsible on behalf of the minister, because what it means that, and the court is clear that he knew by his own admission that he cannot do this, but yet nonetheless seeked declaratory order. That means that there was a misuse of court time, as pointed out earlier, but a misuse of state resources. Costs have been awarded against the minister and his counsel. That means that they must cover it. Technically, that now means government, you and I, taxpayers, we're absorbing that cost. Importantly here then, we have to ask ourselves, if it is the case that the minister had an oversight problem, an oversight indiscretion, and behaved irrationally and irresponsibly, should we then still absorb cost for such a person? Clearly this person was incapable of performing his oversight in that instance, and I think it should be the case that the minister absorbs the cost by himself in that instance. It should be a personal cost to Pravin Gordhan, the individual South African citizen, and not to the Ministry of Finance. But with regards to sort of where it stands on the idea of corruption and all of those sort of things, I think the court sort of just said there that claim is at this stage baseless. What that means is that there's no foundation to support the claim here that we may think that Pravin Gordhan had political motivations. But we do know, at least from our own observations, that there were political motivations. I think then the next step, the very clear step is for us to have an actual commission of inquiry into the ideas of state capture, but it must be state capture that is holistically, not one that is specifically about one group of companies, one that looks into the state capture held by financial institutions, as pointed out earlier here. It's like, what is the role of all institutions with regards to that?
Yeah, I mean, the court also clarified around the issue of closing banks willy-nilly, and we saw this in concert, for that matter, with all the banks, one after the other, closing the accounts, talking about that it is at the discretion of a reasonable notice to client, number one, and secondly, it mustn't breach the public policy and constitutionality of the client-bank relationship. All this, it hasn't really been applied. Do you think there's an opportunity now, at least, to litigate from the OKPAY Group?
The first thing is to actually recognize that this was a milestone decision. This is historic and important, and was also by a bench of black judges. As Black First, Land First, we believe that there is no possibility of fairness in the judiciary if it's not transformed. And the integrity and the bravery of these judges must be recognized in society. Remember, at this point in South Africa, everyone, the white-owned media, the politicians, they're making a lot of noise, and everybody must simply follow the script that says that the OKPAY or Gupta-related businesses are bad. These judges actually were sober, and they come to a conclusion that, in fact, OKPAY is the one which was wronged. That is a very important thing. Now, the second thing is to congratulate OKPAY, because here it took up the giants and it basically decimated them. Pravin Gordhan is the Prime Minister of White Monopoly Capital. He was not alone, he was with the banks. Of course, Pravin Gordhan is compromised, Pravin Gordhan is conflicted, he has shares in these banks. They took state resources to fight their own political battles of White Monopoly Capital, and they lost. That point must be made absolutely clear. On the other side, I think we must not say Pravin Gordhan was irrational. We must remember what happened about this application. It happened the same, very late in an afternoon after they had lost the interdict, where they did not want the state capture report to come out. What Pravin wanted is one thing, and one thing alone, that the FIC certificate must come into the public, and then they must abuse it, and they have abused it. The opposition parties, the media, to say, oh, see, there's this 70 whatever transactions which are suspicious. There is no basis for that. This case should never have gone to court. It was all political. It was all malicious.
All right, so let's go to the second element. Quite a bit of ground to cover here. My colleague Audrey Chimwanda takes us through the key implications of this judgment for Pravin Gordhan, the Financial Intelligence Center, and the government and OKPAY Group.
Right, now let's take a look at the implications of the court's decision on Pravin Gordhan. Gordhan's personal agenda in the name of the country's interest has been outed. Also, Pravin Gordhan's bid to position himself as a corruption buster has backfired. For Gordhan, court order exposing his real intentions end up eroding his political heft. Now, taking a further look at the implications for the government. Now, the order gives the government the courage to rein in super ministers who act on their own agendas. Now, taking a look at the implications for the banks, the grounds for OKPAY boycott are under serious questioning now after court's rejection of the 72 suspicious transactions. Still, with the banks, they may be forced in court to declare the reasons for OKPAY account closure that threatened 8,000 jobs. Now let's take a look at the FIC and the implications thereafter. Their boss, Mario Mitchell's conduct under questioning for releasing the certificate, despite Treasury not being a competent authority. Still, with the FIC, it may appear that there is a truth in OKPAY's allegations that the FIC director was complicit in Gordhan's attempts to defame the Gupta-owned businesses. Still, with the FIC, they may be forced legally now to release the details of the 72 transactions or to declare the transactions lawful. Now let's take a look at the implications for OKPAY. Now this vindicates OKPAY's stance that there is a larger political campaign against the group. Also, it opens up opportunities for legally challenging the coordinated account closure by the 4 private banks in South Africa. This might help OKPAY fight a Bank of Baroda's decision to close the group's accounts.
And of course, we're joined now by Adil Nchabeleng. He's the president of Transform RSA. Just your view in terms of the political capital that former Finance Minister Pravin Gordhan has now after this court outcome.
I think from our view as Transform RSA, and good evening to the viewers, is that we are quite pleased that this court actually has decided to actually vindicate here, which was the victim, which is actually OKPAY group of companies and OKPAY company, because this is not the first instance. I am happy that one company took up this particular issue and challenged it in the court of law, because many other thousands of companies have suffered a similar fate but have never had a chance to be vilified and vindicated in the court of law. So this particular judgment is the landmark judgment, because now we can now go directly and take up some of the issues. There are many other victims right now whose bank accounts as companies have been closed and has been shut down. They don't have access to their monies because banks have been willy-nilly taking upon themselves the law and shutting down bank accounts illegally. So in this case where the minister even intervened to perpetuate this kind of a gross smear campaign, it clearly shows you that we have a system that requires all forms of checks and balances. And as civil society, it's our job now to start intervening and interfering within the processes of government and start putting all our leaders at the basis by which their conduct must be actually judged and questioned with regards to the ethics of how they go about. Here, a huge Department of Treasury put itself into an ethical impropriety, which was not necessary in this case. Why would you take a company and isolate many other companies? We've got companies that are generating billions of rands, far more than 6.8 billion, who are making local and international transaction payments. And none of those companies have ever been exposed in terms of international payments, whether it is legal or illicit payments. None of them have ever been dragged into court and have actually been given into a 72-page or so affidavit of showing their transactions with regards to their bank accounts. So what Treasury did in this case, and particularly under the leadership of a minister, of a South African minister, was a gross misappropriation of powers and was really something that has given all of us a wake-up call to say our leaders now need to start thinking very ethical. They now need to actually subject themselves to rules of law and not act out in a rogue manner.
Yeah, okay, sorry, Adele. Cecilia, just the 72 transaction again. We know how that occupied the imagination and news headlines as well. You can understand from the OKPAY group of companies the reputational damage that it caused, because anything that has been associated with them was targeted, scrutinized, and pressured to either break ties with them, etc. Do you think that the perception will change after today's court developments?
I think the perception, I mean, it's really difficult to say whether the perception will change. I mean, if you read some of those articles that emerged quite soon after the judgment, it would seem as though they would wanted to spin it in a way that there was nobody won this, there was no winners in this case. But in actual fact, the judgment was very clear, both in terms of the FIC certificates and in terms of Mr. Gordhan. It was very clear that these judges had made a decision that that there must be a separation of powers, and what he had done was wrong. So. But I mean, I think that perceptions need to change over time, and one of the big delays obviously has been this, it's come into this milieu of state capture, days after days after days of Gupta stories. How do you change perceptions? It will take a great deal. So I think that everybody at this particular group, and I know as journalists and everybody, we're waiting for this commission of inquiry. We're willing to, I think that every single inquiry will work in favor of whatever's the truth. What needs to be uncovered is what really is going on here. But Adil also mentioned something really important. The whole world keeps on, the 72 transactions which don't show anything, don't show any good, don't show any bad, they don't show anything. They are actually meaningless transactions. The OKPAY group got a forensic to go and look at it and discovered the same kind of thing. And some of them were actually after the banks had closed. I mean, it was a very odd collection of numbers or things.
In a nutshell, these particular, or bringing the FIC certificate was not relevant to the case, as you're saying. I mean, there were 9 million other transactions, I think, in the same financial year that were regarded as being suspicious or that were under the radar of FIC. But I just want to, sorry, Adil, I just want to look at now the opportunity for OKPAY to litigate, to again wanting answers and questioning the banks on why the accounts were closed in the first place, based on the fact that now we have this result.
Well, Cindy, what the court ruled today, for people who know the law, it was materially, one, substantial, two, it was factual. What OKPAY has to do now is to push the Minister of Finance, and unfortunately, it's not Pravin, it's Malusi, but it's government, it's the Minister of Finance, acted wrongly against OKPAY for failing to defend and or protect a company that is operating and conducting business legally in South Africa regarding the bank's conduct towards them. The Minister of Finance or the Treasury has failed this company called OKPAY. Now, what OKPAY is supposed to do is to approach the Treasury and say, Treasury, we've been wrong done. And the previous Minister of Finance failed, as the court has ruled, to conduct himself in a manner that is supposed to defend this company that has done nothing wrong. And also the banks have conducted themselves in a manner that is contrary to public policy. But what OKPAY is supposed to do is supposed to approach the Minister of Finance now and say, Minister of Finance, can you approach these commercial banks, 4 of them which happen to be major banks in the country?
Now we're going to go back to the courts for another declaratory order.
It's not a declaratory. No, we don't have to go to court. We don't have to go to court. OKPAY is supposed now, with the court ruling, to approach the current Minister of Finance. Let's leave the people. Let's look at the Treasury. It's supposed to approach the Treasury. And Treasury, the court has ruled that we've been wrong done. The conduct of banks towards OKPAY is wrong. Treasury, can you intervene? The court has said the Minister of Finance is empowered by the Constitution as well as the FICA, the FIC Act of the country.
I don't see that one playing out well, because
it has to happen.
Look, this judgment has certain limitations as to what it speaks. The judgment at no point said the banks were wrong. It just said the minister and party to the banks who sort of supported the declaratory order were wrong in that instance. The judgment doesn't yet say that the banks were wrong in closing these accounts, and therefore, no, we shouldn't go back to the court. But Minister Malusi Gigaba now has an opportunity to give a political remedy to the situation. It shouldn't be the case that South African companies are prematurely judged and the bank accounts are closed. It shouldn't be the case, because it's clear here, none of these banks performed this action based on a substantive evidentiary body. They based it based on speculation. And your colleague is right. We need to wait for the commission inquiry to give us some sort of clarity on where we stand on state capture, because many people in this country willy-nilly go around talking about state capture when there's no real evidence by a credible body that speaks to this.
Yeah, but that's my point. While we wait for the judicial inquiry into the broader scope of state capture, the fact is that businesses have been closed or is under distress. There is also the reputation with suppliers, employees, ourselves not having certainty whether we will get paid at the end of the month, because now the Bank of Baroda has been under pressure, and that's in the public domain. Should they litigate now, in your view, Tsepo, while we wait for other processes?
I think I've held course from the beginning of last year, 2016, that OKPAY needed to have approached the courts for relief. But that's water under the bridge. Where we are today, we know one thing from this judgment, that power corrupts and absolute power corrupts absolutely. That is indicative of really the Minister of Finance we had in the name of Pravin Gordhan. He had far too much power that, in fact, there were no boundaries to the level at which he would go to be vindictive against his victims. And OKPAY, the group, together with the 7,500 employees of this group, have been victims of this vindictive former Minister of Finance. Has there been injuria? Most certainly there has been. What is the remedy? Sincerely, the remedy is for OKPAY now to approach the courts to lodge a massive lawsuit for damages, because certainly they have been damaged, and I believe that they will have solid grounds which the banks that have acted in a cartel conduct, which is unlawful, they will not be able to effectively produce an affidavit that can show that they've acted above board. But if anything, the question that must now be asked sincerely, what is former Minister Trevor Manuel's influence, involvement, conduct, and more so in terms of what is alleged of him now having resorted to pressurizing Bank of Baroda? And the question is asked, where does former Minister Trevor Manuel come in? It's because he's the chairman of Old Mutual. Old Mutual is a controlling shareholder of Nedbank, and because of our banking rules in this country, Bank of Baroda's back office is run by Nedbank. You have to have an agent. And as a result, he is therefore abusing his position as the chairman of Old Mutual to go and exert undue, unlawful pressure, which itself is an abuse of power, on this bank. And therefore using his influence, even on his buddies in the Reserve Bank, particularly with the Registrar of Banks, who are in fact, if anything, presiding over the violation of rights of a citizen under the Constitution that demands that dignity must be upheld. So Trevor Manuel has to be now hauled up to the coals. And certainly I think litigation will assist in that regard. Pravin Gordhan, he must be hauled over the coals. And litigation, a massive lawsuit against him personally for the conduct that he engaged in, which was absolutely very injurious on the company, and everybody knows that. And those are the things that really have to be pursued. In fact, if OKPAY directors do not go and now lodge a massive damages lawsuit, they themselves would be guilty of dereliction of duty as directors of fiduciary duty. And the CEOs of these banks, by the way, who acted unlawfully, who became politicians, when the memorandum of incorporation of their respective banks do not allow them to be involved in politics, they themselves have damaged the interest of the companies or the banks that they run, and they too must be held responsible.
In terms of going to court, you obviously have to have evidence that is beyond reasonable doubt and not probabilities. It would be difficult for OKPAY Group and the Guptas to prove the stance that they've held, that there is undue political pressure, targeting the
The issue is that we know that is not for court, that is not for judges. It is for us as society. We know for a fact what's going on here. What's going on here is that white monopoly capital, having employed Pravin Gordhan, by the way, putting extreme pressure on the president to do so, has used him to make sure that competition to white monopoly capital, which in the form of OKPAY is basically dealt with. What must happen is all the accounts must be reopened, and as a society must put pressure on those banks. The Bank of Baroda must be told by everybody who knows something about justice, it must not shut down the bank accounts of OKPAY. And then over and above that, we must not allow Pravin Gordhan to get away with murder. He must pay, and we must make a big call to the current Minister of Finance not to use our money unfruitfully on these battles, political battles of Pravin Gordhan.
Look, that's a very nice argument to agree with as a member of the public. But there's something in the judgment which is a bit worrying for me at this stage. And at this stage, it says, the court says that it has no grounds to believe that there was political interference by the Minister of Finance. It makes that very clear at this stage. In fact, that judgment goes as far as saying that to claim that there was political interference may be to some extent defamatory towards the minister. I think that's a political question. It needs judicial sorting.
There's another element. I agree with him. The court was not clear on that. However, the minister or the former Minister of Finance acted in his capacity as the Minister of Finance, and I like what Tsepo said, to say, I'm taking this matter to court, I'm disregarding my duties. Now, the current Minister of Finance, the honors rest with Malusi Gigaba, to say to Pravin Gordhan, you were supposed to have executed your duties in this manner, and you failed to do so, therefore you will cover the cost of going to court. We cannot allow, and I agree with Andy, we need a judicial inquiry in the banks, but we cannot allow ministers in this country, any minister in this country, to fail to perform their duties and then they want the court to decide on which duties they must perform. And they make us, as taxpayers of the country, to pay for their error of judgment. The Minister of Finance is supposed to manage the Reserve Bank, is supposed to oversee the fact that banks are conducting themselves.
The banks are a criminal cartel.
And the Minister of Finance, the banks fail.
Let me just get Cecilia in here. Besides losing face as former finance minister, Pravin Gordhan essentially has nothing else to worry about because the cost will be incurred by the taxpayers, Cecilia. But just in ministers going over and above the ambit of cabinet and what their jurisdiction is, clearly what the court has stated that there are certain relationships or limitations, confines that the ministers need to observe. He didn't have to bring this court case before the bench, and now we're sitting with a damages cost that we should not have incurred in the first place.
Well, one of the things that is clear is that he brought this whole case unnecessarily, that it was an unnecessary case. He acted as a lone wolf in a cabinet. The judgment does go into the ministerial committee around banks and has something, does say something about that, and says that perhaps that wasn't the right way to go about it, but nevertheless, Pravin Gordhan acted by himself. He, as the Minister of Finance, he decided to bring this case by himself without consulting with his cabinet colleagues. And we know this. This is confirmed to us. It's not even a secret. The essence is that you can't act on your own when you're a member of government or of the executive. You have to act in concert with cabinet, and it brings this whole story comes into what was going on in cabinet, the factionalism that was happening there. How Gordhan, who was supposed to be part of that interministerial committee, never went to any of the meetings. His behavior was deliberate and very carefully done, and that is because he saw himself as above everybody. And so this is the consequence. If you don't take advice from your legal fraternity, whether you act as a lone person, you're acting out.
Sorry, Cecilia,
something.
we're seriously running out of time.
There.
We go to my colleague now, Audrey Chimwanda, for more on exactly what Pravin Gordhan's game plan was and how it was exposed today.
Right now, let's take a look at what was Gordhan's political game. First point, a court order to bar the government's intervention in a case of brazen collusion by private banks. Also, a court order to cover up serious allegations of banks' collusion to shut down OKPAY businesses. And to fuel the general perception of a corrupt Gupta family and a corrupt president by extension. Another point there, critics also say that Gordhan's tirade against the Gupta family may have been dictated by white monopoly capital. Gordhan's political game. The first point, approaching the court over legal question that he had already been advised by 2 legal experts. Also seeking protection from court, knowing fully well that he had no obligation to intervene in the first place. Created unwarranted suspicion over OKPAY bank transactions by attaching unrelated and insignificant FIC certificate to his application. Also insinuated that the FIC certificate pointed to serious state of affairs despite the non-conclusive nature of the FIC report. Another point there, he tried to broaden the perception of corruption around the Gupta family by introducing Jonas bribe offer claim into the very case.
Thanks so much, Audrey Chimwanda there, just breaking it down fast, the judgment where the OKPAY group were vindicated today with regards to, number one, the then Finance Minister Pravin Gordhan seeking protection from the courts. Earlier on, Andile, you were saying that, former Finance Minister is manipulated, he's conflicted because of white monopoly capital, and some people will not buy that. They would say he was, an astute member of cabinet, etc., etc.
No, but this judgment clearly shows that Pravin Gordhan, as we have been saying, he's a bulldog of white monopoly capital. And in fact, he has been very abusive, and how he used the power of treasury that he comes with being a minister to undertake this court, how he revealed, for instance, this FIC certificate to the media, because that's what it was about. We must remember, when Pravin Gordhan and his gang, including the former public protector, could not win in getting out of a bang in terms of that report, they went to court with this frivolous, vexatious and malicious litigation. We were clear as BLF from the beginning that Pravin Gordhan is a minister of white monopoly capital and banks. As we know, there was an interministerial group that's supposed to have looked into the matter. He did not attend one meeting. Why? He's conflicted. Instead, he ran to court and with the banks which he has served. We're very happy that, in fact, he has lost his job, but we're now worried about the current minister. What is the Minister Gigaba going to do? Is Minister Gigaba going to be a minister and show leadership and tell the banks to open these accounts? Is Minister Gigaba going to? He must. Jobs are going to be lost. He can say, on the basis of this court decision, actually, you must give us banks. Banks have not given reasons, by the way, why they shut down these accounts. It cannot be allowed.
Okay, Mzwanele Manyi is with us, who's with the Professionals Forum. Good evening to you, Mzwanele, and thanks so much for joining us. Let's just look at the FICA certificate, and you were quite critical as well, in the sense that this is a legal exercise where the minister didn't have the jurisdiction to source this confidential information. We'll start with you, Adil, while we're waiting for Mzwanele.
I think the issue, let's try and maybe sort of paint a very clearer picture. The judgment is not just about the OKPAY company. It's about what has been done wrong in the past and currently in the present, whereby cases of this nature have gone unattended to. One, the Guptas have been vindicated in terms of OKPAY and their related activities. Remember, when this particular matter happened, it was during the time where there was a preeminent cabinet reshuffle, and at the same time, there was a call for Zuma to step down. So I think this case is a landmark case in the sense that it takes us back to the fact that we have a small cabal. Within Treasury, we have a small cabal. Within the opposition parties as well, we have a small cabal within the South African civil society that is actually been interfering with matters that are very serious and pertinent, which is to start dealing deliberately with competition in business. We know today that the OKPAY group of companies has been a massive competitor for white monopoly capital. And as a result, we are not gathered today here to debate a case on the basis of defending the OKPAY, but to stand very clear that rights of constitutions must be respected irrespective of what individuals and entities, such as, for instance, the people and consultants running Treasury feel. You have a capture of our Treasury Department today, which does not even know how to move forward unless it is instructed by certain quarters in South Africa, whether it is the Stellenbosch quarters, whether it is to the financial institutions, which is the bank, and in this case where a bank can go about and shut down people's businesses, which means your life as a person, people's workers' income, people's pensions are all affected. So as a result, the court has done the right decision, but the decision must be taken further in now pronouncing clearly that no bank in South Africa can willy-nilly go about based on a suspicion, hearsay, or some kind of a smear campaign.
It should be a case that we're all equal before the law, including in business. And it's very interesting. I think for the purpose of context, I mean, we've been on this literally a year. I think the first day when I joined...
8 months.
or so we were on this particular story, but looking at to the extent where the former finance minister went to the trouble of getting the 72 suspicious transactions from the director of the Financial Intelligence Center, Mr. Mitchells, while on the one side he's saying that he actually doesn't want to get involved, he doesn't have the jurisdiction or power, he seeks for the courts to cover him.
That's where the problem is. You have a minister of finance saying, I don't want to get involved. The very same minister of finance goes to one of the agencies of the Treasury, which is FIC, and say, give me information on how this company called OKPAY have been conducting business. Now, why do you want to get information on how OKPAY has conducted its business when you said you don't want to get involved? After that, you don't stop there after getting information. You take that information, you don't give it to the court, you don't question OKPAY, you give it to the media to release in order to portray a situation whereby, you know, when you say to a noble citizen, the 72 questionable transactions that OKPAY has conducted, a noble citizen of this country will get excited. And today, the court disregarded, actually, that list of 72 transactions. They looked at the conduct and the manner that the former Minister of Finance was supposed, or he behaved. The court today ruling, it's not about the content of the case. It's not mainly about the substantive part of the case. It is about the Minister of Finance saying, my hands are clean, I don't want to get involved in the dirty work of FICA and of the
Mind you,
banks.
over and above
OKPAY.
that, he then took an affidavit from then his deputy, Mcebisi Jonas, to say that the Guptas had bribed him, or there was 600 million rand on offer in his application for the court to protect him on what he says he was being hounded on.
The so-called certificate is, and the conduct, the length at which Pravin Gordhan went to unlawfully obtain. By the way, the certificate was unlawfully obtained,
yeah.
And secondly, it was unlawfully constructed. That certificate had no basis in law, and we challenge Mary Mitchell to please, currently, whilst you are still the head of FIC, come to the studio here so that we don't shave your head in your absence and defend your conduct of having unlawfully issued a certificate that should never have been. That is a grounds for litigation, or because it's injurious, because there was malice. That is a grounds to prove malice. However, on the other hand, is this, if the Guptas really had captured the state, how can somebody who has captured the state have their accounts closed and they can remain so helpless? How can it make sense that somebody who's so powerful, so influential, and yet their accounts can be closed? Since when did Johan Rupert ever suffer from such? Since when did Loanmen, for example? None of those have ever had any problems. But yet, the people that we are told that they are the ones that are running this country, and yet they can have their means of doing trade, they can have their constitutional rights violated without any recourse. What kind of a country is this? So these things that we are saying here, we say in South Africa, wise up, wake up, for if you do not do so, cry for your own children, because tomorrow we are going to be in an abyss.
All right, Tsepo, hold that thought. As we conclude now, the court case by Pravin Gordhan has seen some sensational stories being published on OKPAY Group and the purported 72 suspicious transactions. But the court verdict today exposed the media propaganda that Gordhan sought to peddle. Let's go to my colleague, Audrey Chimwanda, for more.
Now let's take a look at what the media and the propaganda over the case has been. The former Finance Minister Pravin Gordhan said that the Guptas were hounding me. Now let's take a look at what was revealed in court today, that Gordhan's court application was clearly unnecessary and that the hounding charge was baseless. Taking a look at further propaganda from the media, Gordhan lodges explosive affidavit exposing 6.8 billion rand of what he calls dodgy Gupta transactions. Let's take a look at what was revealed in court today. They ruled that alleged suspicious transactions that were worth 6.8 billion were irrelevant and unproven. The Gordhan blows whistle on Gupta's 6.8 billion rand suspicious and unusual payments. This, of course, coming from the media propaganda. The court says that the generated 9 million suspicious transactions that were reported in that year itself, and that it does not prove any guilt. Media propaganda over the case further says that the Guptas were plotting against Treasury and me. Of course, this is coming from the former Finance Minister Pravin Gordhan. The case was dismissed. Actually, it suggests that it was Gordhan who may have been plotting against the Gupta family this whole time.
Thanks so much. Audrey, we go now to the Special Projects Editor, Cecilia Russell. I mean, there had been 9 million other suspicious transactions in that FIC report, or at least in that financial year, and none of that had been proven guilty. Your reaction there?
Yes. There was one article, there's always a loan article that I read today, which it looked particularly at those transactions and questioned whether Treasury, the FIC, actually anybody's got a plan about finding out what is really going on as far as transactions are concerned, or illegal transactions are concerned, and why is it that the emphasis has been completely on just the Gupta family and the Gupta family's businesses. But I just want to clear something up that people are talking about. That this particular judgment puts the emphasis on the client and a bank relationship again. I think that the future for the Gupta family and for the OKPAY, a group of companies, in the future, if they want to fix this, is that they need to litigate in that space. I think it's very clear that a minister can has executive authority and therefore should use it clearly and independently. I mean, as within the
Adil, sorry, Cecilia. Adil, just your view and how the mainstream media, and Cecilia, of course it's very sensational in itself, perpetuating this anti-Gupta narrative.
In terms of the media's role, right? Mm-hmm. I think Cecilia has just wrapped it up very nicely. Now we have a situation whereby, remember, this campaign was run by the media to make sure that they actually completely trash and trail down and create an environment of distrust on a company like any other. That could have been an Anglo Gold. This could have been an Anglo-American company. But here it happened to be a Gupta, a South African-based company which is black, and majority of employees happen to be black people. And in this case, a competition as well as a fierce, dominant player in the media space. So what do other media houses do to kill their competition is you go after them, you destroy them. But not only that, you collaborate. Remember the report of saying that the banks illegally closed the accounts of OKPAY was based on suspicious so-called fraudulent activity. Here the court case has said there is nothing suspicious. The 72, transactions which were reported really had no even significant bearing because it really didn't make any much sense. But yet the banks went forward. 4 banks colluded to do a closing down and closure of a business bank account.
I mean, I think reputationally it's going to be a mammoth task in trying to undo what's been orchestrated very well, for that matter, over the past couple of years. The court case in itself may be interpreted differently, as Cecilia had alluded to. But the fact,
OKPAY should sue in America. Some of these banks that have got links in America, they should sue them in America because OKPAY is an international company. It operates internationally. Its reputation has been damaged internationally. They should consider seriously to bring litigation in the U.S. courts where they can sue for gazillions of rands, as opposed to here in South Africa where maybe there will be some constraints. And I think that they will hold the day. And these banks, I can assure you, none of them, they had the opportunity in this case to be able to come to court with clean hands. They could not come to court with clean hands. If anything, it showed us that these banks themselves are implicit in the harm that has been perpetuated against this company, and therefore their collusive conduct itself is criminal and it should be investigated as such. But sue them in America, then they will wake up and the CEOs of the banks will lose their jobs, and they must lose their jobs.
We seriously have to go. Can we take this offline? I beg your pardon.
The Minister of Finance should not allow the legal cost of this process to be shifted to taxpayers.
We cannot allow. We need a black bank, we need a state bank, and we must insist these accounts must be open of OKPAY.
Yeah. No. I know I'm in good company, so we have to go. That's where we'll leave it. You at home, thanks so much for joining us. We're back after this.